Good morning. Chris Vernon with Vernon Litigation Group. Today I want to talk about Uber. Uber's been in the news recently about their tarnished image, if you will, including issues relating to sexual harassment, sexual misconduct, both inside the corporate offices as well as on the road. And there's a lot of things we could talk about with respect to Uber, as well as the trend towards some of these companies attempting to clean up their image and change their culture. But I want to talk about one specific issue, and the specific issue relates to consumers in all industries. It relates to businesses in a lot of industries, and that specific thing is arbitration. If you've read some of the articles or seen some of the reports regarding Uber, they're no longer requiring certain people to arbitrate disputes with them. So what the heck is arbitration? A lot of people ask me that. And one of the confusing parts is there's a lot of different kinds of arbitration. But arbitration very generally is private court. It's court outside of the public eye. And whether you know it or not, a lot of disputes get resolved, especially business disputes and consumer disputes get resolved in arbitration. And there, again, it's not as public. So it's harder to see what's going on in arbitration. Now there's good and there's bad arbitration, but you need to be aware when you enter into an agreement with just about any business these days, a consumer agreement or business to business, there's probably a good chance there's an arbitration agreement. And whether the agreement is fair or unfair is extremely important. Unfortunately today in America, a lot of business transactions, significant business transactions, and some significant consumer transactions end up in some type of dispute. And if you have an arbitration agreement that is fair to you, fair to your business, or fair to you as a consumer, then you have some leverage in attempting to resolve your dispute without even a fight. On the other hand, if the arbitration agreement you entered into as a business or a consumer is very unfair to you, then when you attempt to pursue your rights, you may not have much leverage at all and might find it's not worthwhile to pursue your rightful claims. So be careful, and sometimes it'll take a little research to figure out what kind of contract, what kind of agreement you're entering into, and whether your rights to a jury trial or a trial in front of a judge have been waived and you're being pushed into arbitration, and if so, is it a JAMS arbitration? Is it a AAA arbitration? Is it a regulatory arbitration? Is it a non-binding arbitration? There's a lot of different nuances there. And I would suggest if it's anything significant that you consult a lawyer before you sign the document and get some answers from somebody who fully understands arbitration agreements. And be wary if you're signing agreements in which you're waiving your right to what appears to be a fair arbitration as well as a judge or jury trial. Remember, whatever it is, let's make sure our money's working for us and not for somebody else. Have a great day.